"You can't be serious," the assistant district attorney said, not bothering to lower his voice. "She drove up here in a Honda." He said it to his second chair, but he said it loud enough for the woman walking through the courtroom doors to hear, and that was the point. Her name was Theodora Teddy Briss, 41, a solo practice above a dry cleaner on a side street in the Outer-Borough. And the Honda was an 8-year-old Civic with 203,000 miles on it. She set her briefcase down at the defense table, took off her coat, folded it once over the back of the chair, and looked across the well at the prosecutor with the kind of expression a tradeswoman wears when somebody tells her the job is too big. The clerk who watched her pell 22 years in the county of Fenimore wrote one line in the margin of her docket sheet: "New defense counsel, Brooklyn plates, doesn't seem to care." It was 8:43 on a Tuesday in October. The case was People versus Hatch and Vidal. The two defendants, Aaron Hatch and Daniel Vidal, 19 and 20, sophomores at the State College up the highway, were sitting on the wooden bench just inside the bar in dark sweaters their mothers had pressed for them. Aaron's right knee would not stop bouncing. Daniel had his hands folded so tightly the knuckles had gone white. They had been charged 11 weeks earlier with the armed robbery of a gas station on Route 9 at 1:40 in the morning. $620 from the register. A pellet gun never recovered. And the entire case rested on one eyewitness, the night clerk, Verna Mott, who had picked them out of a 6-pack photo array 41 hours after the robbery. The boys' families had hired Teddy Briss after firing the public defender. The judge, the Honorable Ross Calder, 63, a former prosecutor, 14 years on the bench, had read Teddy's notice of appearance over the weekend and told his clerk Monday morning that he expected the trial would last 2 days and the jury would not be out for very long. He had not said which way. "Counsel," Judge Calder said now, taking the bench, glancing at Teddy over half glasses, "you are from out of the area." "I am, Your Honor." "You filed a motion in limine yesterday." "I did, Your Honor." "At 4:58 p.m. "I did, Your Honor. It is a 4-page motion. The state has had it overnight." The Assistant District Attorney J. Bryant Holm, 35, the youngest deputy chief in the office's history, half rose. "Your Honor, the state objects to the motion in its entirety. Eyewitness identification is the bedrock of—" "Sit down, Mr. Holm," Judge Calder said, but mildly. "Counsel, I have read your motion. You are asking me to suppress the in-court identification before the jury hears it. I am asking the court to hold a wait hearing this morning, before the jury is sworn, so the court can determine whether the procedure used to obtain the witness's identification was so suggestive as to taint any later in-court identification. The case law is—" "I am familiar with the case law, counsel." "Then the court is familiar with the procedure," Teddy said. She did not raise her voice. The state's only witness was shown a 6-pack photo array 41 hours after the incident. 5 of the 6 photographs are men in their 30s. 2 are men of plainly different ethnicity than my clients. The fillers are not in any reasonable sense fillers. The witness was told, in the affidavit of the investigating officer himself, paragraph 11, page 4, that the suspects were in custody. The witness then identified the 2 photographs of men in their late teens or early 20s. The state has not produced the original photograph spread shown to the witness. The state has produced a reconstructed spread prepared 2 weeks after the identification from the investigating officer's recollection. The courtroom was very quiet. "I am asking the court," Teddy said, "for 1 hour, with the witness on the stand outside the presence of the jury. After that, I will sit down and the court will rule." Judge Calder looked at the prosecutor. Holm was on his feet again. "Your Honor, with respect, this is a stalling tactic by counsel who has been on this case for 9 days. The court should not indulge." "I will indulge an hour, Mr. Holm." "Bring up the witness. The jury panel will stand down until 10:30. Verna Mott took the stand at 9:11 a.m. She was 46. She was a night clerk because her son had cerebral palsy, and the day hours she worked as a home health aide did not pay the rent. She wore a beige cardigan and small silver earrings. She looked, the clerk Pell wrote in her margin, like she had not slept in 3 nights. And she had not. Teddy stood up. She did not move to the lectern. She stood at her chair with her hands at her sides. Miss Mott, good morning. My name is Theodora Briss. I represent Aaron Hatch and Daniel Vidal. I am going to ask you some questions, and if any of them aren't fair, I want you to tell me so. Do you understand? Yes. You were working at the Lodestar station on Route 9 on the night of August 2nd, into the early morning of August 3rd. Yes. 2 young men came in at approximately 1:40 a.m. Yes. What was the lighting in the store that night? The fluorescents over the counter, they were on. One of them was buzzing. The one over the coffee station was out. For how long had the one over the coffee station been out? 3 weeks maybe. The manager had ordered a replacement. So the area near the counter was lit. The area near the coffee station, 12 feet from the counter, was in shadow. Yes. The 2 men came in from where? From the cooler. Attic light processed? From the cooler. So they had been in the cooler aisle, past the coffee station, in shadow. Yes. How long were they in the store before they came to the counter? A few minutes, maybe 4 or 5. I was reading a magazine under the counter. You did not look up when they came in. You looked up when they came to the counter. Yes. How long? In your best estimate. Did you have a clear, lit view of either of their faces before the shorter one put what you believed to be a gun on the counter? The witness was quiet. The courtroom was quiet. Judge Calder did not move. Maybe 2 seconds, maybe 3. 2 seconds, maybe 3. And then your eyes were on the gun. Yes. And then you were ordered to face the wall, and you faced the wall for the rest of the encounter. You did not see either man again. No. You heard the register open. You heard footsteps. You heard the door. Yes. How long? From the moment you faced the wall to the moment you heard the door close. About a minute, maybe less. Thank you. Now, Miss Mott, I want to ask you about what happened in the police station 41 hours later. Holm rose. Objection. Foundation. Overruled, Mr. Holm, Judge Calder said. Teddy did not look at the prosecutor. She kept her eyes on the witness. The detective showed you a folder of 6 photographs. Before he opened it, what did the detective say to you? The witness hesitated. She looked at Holm. Then she looked away. Ma'am, Teddy said gently, what did the detective say to you? He said, they had the boys in custody. He said it would be helpful if I could pick them out. He said they had the suspects in custody. Before he opened the folder. Yes. And then he opened the folder. Of the 6 photographs, how many showed men in their late teens or early 20s, as the 2 men in your store had appeared to you? 2. Minus 2. Of the 6, how many showed men with the build the men in your store had appeared to you slim? The shorter one, perhaps 5 to 8. The taller, perhaps 6 foot. 2. And those 2 were the same 2. Yes. And those 2 were Aaron Hatch and Daniel Vidal. Yes. So of the 6 photographs the detective laid in front of you, 4 were of men who could not, by any of the descriptions you had given the responding officer that night, have been the men in your store. Yes. And you picked the only 2 who could have been. Yes. How long did it take you to do so? He said the detective said it was 19 seconds. 19 seconds. Miss Mott, may I ask you something? And please understand, I am not trying to embarrass you. When the detective put that folder in front of you and told you the boys were in custody, what did you understand him to be asking you to do? The witness looked at her hands. Her voice was very small. I understood him to be asking me to pick them out. You understood him to be asking you to confirm what he had already told you. Yes. Thank you, Miss Mott. I have no further questions for the purpose of this hearing. She sat down. Holmes stood up. He cleared his throat. He asked the witness 11 questions about her training in observation, of which she had none, and the certainty of her identification of the defendants in the courtroom, which, when he asked her to make it, she could not bring herself to make. She looked at Aaron Hatch. She looked at Daniel Vidal. She put her hands flat on the rail of the witness box. I am not sure, she said. I am not sure it was them. I think the detective and I I think we built it together. I want to say so before God." The courtroom was so quiet, the clerk Pell could hear the radiator click on in the back wall. Judge Calder did not move for a long moment. Then he set down his pen. "Miss Mott, you may step down." Counsel, approach. At the bench, with the witness gone and the court reporter's fingers above her keys, Judge Calder removed his glasses. "Mr. Holm, is there any other evidence the state will present that goes to the identification of these defendants? Any fingerprint, weapon, surveillance, or statement by either defendant?" "Your Honor, the inspector en res." "Any other evidence at all?" "No, Your Honor. You have a witness who has just told this court, on the record, that she cannot identify your defendants and believes her prior identification was the product of a suggestive procedure. You have a reconstructed photo array prepared after the fact by your investigating officer. Mr. Holm, are we still trying this case?" "Your Honor, the state respectfully requests a brief recess to confer with." "You may have until 10:30. Step back." At 10:22, Holm came back into the courtroom with the elected district attorney himself, Conroy, a courteous gray man who had been the elected DA for 16 years and had not seen the inside of a courtroom in 9 of them. He did not sit. He stood at the state's table and addressed the bench. "Your Honor, after consultation with my deputy and review of this morning's testimony, the people move to dismiss the indictment as to both defendants with prejudice. The people will refer the conduct of the investigating officer in the preparation of the photographic array to our internal integrity unit. The people apologize to Mr. Hatch and Mr. Vidal." Judge Calder did not look at the prosecutor as he said the next words. He looked at the 2 boys. "Mr. Hatch, Mr. Vidal, stand up, please." They stood up. Aaron's mother, in the gallery, made a sound and then put her hand to her mouth. "The motion is granted. The indictment is dismissed with prejudice. You are free to go. The bond your families posted will be returned within 10 business days. I am going to add something to the record that is not strictly necessary. 11 weeks ago, 2 college sophomores were charged with a serious felony on the basis of one identification that ought not to have been obtained in the manner it was obtained, and that identification was not interrogated by anyone in this building until last weekend, when an attorney from a county 4 hours south of here read a file and wrote a motion. I do not take it kindly when this court is asked to ratify a procedure of the sort just described to me. Mr. Hatch, Mr. Vidal, I am sorry for the 11 weeks. Counsel, thank you for the motion." He paused. "One further matter. Mr. Holm, your office will, within 30 days, certify to this court in writing that it has reviewed every active felony file in which Detective Lauren was the lead investigator in the past 5 years, and that no other identification was obtained by the procedure described to me this morning. Are we clear?" "Yes, Your Honor." "We are adjourned." The gavel was a small, precise sound. The clerk Pell wrote one more line in her margin. 10:34 a.m. Dismissed with prejudice. Counsel, T. Briss. Outside, in the courthouse corridor, with its scuffed marble and its smell of old paper, Aaron Hatch's mother gripped Teddy Briss's forearm with both hands and could not speak. Daniel Vidal's father, a man who fixed boilers for a living and had lost 40 hours of work in the last 11 weeks driving back and forth to this building, shook her hand and held it. Daniel himself stood at his father's shoulder, crying without sound. Aaron, beside him, was not crying yet, but he would, in the parking lot, with his face against the side of his mother's coat. Holm did not come out. He had gone back into his office and shut the door. The elected district attorney did come out. He waited until the families had gone toward the elevator, then approached Teddy in the hallway and offered her his hand. She took it. "Counsel," he said, "I have been the district attorney of this county for 16 years. I have never had a morning like this morning. I am sorry it was today, sir. I am not." He looked at her for a long moment, and what he said next, he said quietly, only to her. "I read your motion last night. Holm gave it to me at 9 p.m. and told me it was nothing. I read it twice. I told him this morning to be ready for it. He was not. That is on me, and on him, and not on you. Drive safely back." He walked away down the corridor. Teddy walked out of the courthouse into the white October sun. Her Civic was where she had parked it, in the visitor's lot beside a row of pickup trucks. She sat with her hands on the wheel for a minute before she turned the key. She did not think about the case. She thought about the line in the detective's affidavit, paragraph 11, page 4, which she had circled in red ink at her desk at 1:40 in the morning on a Saturday 5 days ago, when she had read the file a third time and noticed what nobody had bothered to notice, the first or the second. Then she started the Civic and pulled out of the lot and turned south onto the highway. The clerk Pell would tell her husband over dinner that what she had seen that morning was a thing she had not seen often in 22 years on the inside of a courthouse, a quiet, prepared lawyer doing the work the system was supposed to do and had not, doing it without making a show of it, doing it because it needed doing for two boys whose mothers had pressed their sweaters. Her husband, who had driven a school bus for 30 years and had no use for lawyers as a rule, would listen and say, after a while, that he was glad somebody had read the file. Late that night, Teddy let herself into her office above the dry cleaner. The hallway smelled, faintly, and not unpleasantly, of pressing steam. She did not turn on the overhead light. She set the file down on her desk, wrote in block letters on the cover, "Dismissed with prejudice, 10:34 a.m., and put it in the cabinet. She watered the spider plant on the windowsill. She turned out the desk lamp. Through the window, the avenue was quiet, and somewhere on Route 9, two boys were home with their mothers, and an elected district attorney was sitting in his office with the door shut, writing the certification a judge had required of him, and a witness was sitting on the edge of her son's bed with her hand on his hair, and the world, in its small, careful way, had moved. She locked the office door behind her. She got into her Civic. The radio came on low, a man reading the late news. She drove the 4 blocks home through streetlights, and she set the briefcase by the door, and she did not, for once, take it inside the bedroom with her. It would still be there in the morning. So would the next file. So would the work. For tonight, it was enough that the work had been done.